So there were many ways to interpret the criminal code. Now there is only one, and it was described by Dreiger. Today there's one principle or approach, namely the words of an act are to be read in their entire context, in their grammatical and ordinary sense, harmoniously with the scheme of the act, the object of the act, and the intention of Parliament. So we've got the ordinary sense, the scheme of the act. It's part of a larger statutory scheme, and they presume harmony, coherence, and consistency between statutes dealing with the same subject matter, the object of the act, and the intention of Parliament. So we need to look at all of those elements in order to determine what the words in the criminal code actually mean. Looking at the McCollum article, this sort of elaborates and kind of picks out a few other points about interpretation. So the plain meaning rule, so read the words chosen by the drafters, review the interpretive section of the statute to clarify the words, and look at the interpretation act. This is standard. You're going to do that first, but it's not going to be an argument to avoid using Dreiger's modern approach. This is just the first step. Then we look at the proposive approach. What is the problem that precipitated the legislation? This is partly internal, because the words should give you some idea of what the purpose of the legislation is. And of course, the golden rule, where don't read the words in order to have something absurd come out. So this is internal interpretation, looking directly at the words of the statute. And it's the first step in your interpretation process. Next, we've got 5 or 6 external things to look at in order to interpret the statute. So the common law is the first thing, and it provides an authoritative interpretation. There are as we saw in Section 43, there are many common law cases that limit the meaning of the words in the code. Or they may broaden them, or they may clarify unclear language, or perhaps they assess the constitutionality of a part of the code. Then look at the legislative intent, and there's a few ways to look at that, but we're trying to understand the purpose of the statute. They may state the purpose of the statute in the statute. This is rare. You may also look at the legislative history, and some aspects are more persuasive than others. So the sponsor of the bill's acts, generally their comments are very persuasive. The committee that recommends the statute, their comments are also persuasive. And still persuasive, though less persuasive, are the comments of the legislatures during the debates. When we look at the legal context, the laws that are created came from somewhere. Generally, there were laws before that dealing with that subject matter, or maybe there were none. But if there were some, were they repealed? Were they overturned? Was this new law meant to fill a gap in that legal context? And if there were none, well, that's an interesting legal context as well. Legislative policy context. So what was going on in the world that led to this statute or this act being created? So the newspapers may provide an example. For example, I think the Firearms Act related to the regulation of firearms in Alberta was precipitated from the Montreal Massacre. There are also official guides to interpretation. These are not binding, but they do show how the government understands its own legislation. So you can look on government department websites for frequently asked questions. There's also the interpretation bulletin that is published by the Canadian Revenue Agency to describe tax law. And lastly, a paradigm case where you just look at the words of the statute, imagine a circumstance where the words would apply perfectly, and then let's see. and then from that situation, imply what the legislator's intent was. Next, canons of construction. These are maxims for reading and writing statutes. There are many of them. Agistum generic is one example. So the phrase means of the same class. So this is used when the legislature creates a list and a general term referring to items on the list. The general term then refers to items of the same class as those on the list. So if you've got a general term and a list of terms that fit in that general term, other things that also fit within that general term will be included. If you don't have a general term and you just have a list of specific things, other things that you could think fall within that class do not fall within that class. External sources of interpretation, you can look at similar statutes because statutes dealing with the subject matter are meant to be harmonious and kind of work together. You may also look at similar statutes in other jurisdictions. So it's possible that the statute came from a lobby group that wrote the law and everyone agreed there was a good law, and all the different jurisdictions made it at the same time. So maybe the statutes are identical, or maybe they're a little bit different based on the jurisdiction. But interpreting this statute based on the way that similar statute has been interpreted could be helpful. You can also look at persuasive precedents. And this is when the statute is based on the statute from another jurisdiction. So you must use the above interpretation method first. And this is the Drager's modern approach, the contextual approach. And if you use that, if there's still ambiguity, so if there's still ambiguity, you can use other principles of interpretation. But what is ambiguity? It has to be real. It has to be, of course, capable of meaning more than one thing. But the meanings must be each equally in accordance with the intentions of the statute. So when you look at the context and the intention of the legislators, they both have to follow those intentions, but still be very different, I suppose. So the contextual propulsive approach set out by Drager must be performed before determining if the words are ambiguous. And it's not just that the courts or writers differ regarding their conclusions on interpretations. So just because people differ in their interpretations doesn't mean that there is ambiguity. If there is ambiguity, the court needs to resort to external interpretive aids, including other principles of interpretation such as strict construction and charter values presumptions, and I don't know what else. So Sullivan has written a lot about interpretation, and she notes 4 historical approaches to interpretation. The first one is the mischief rule, and this is derived from Hayden's case in 1584. What do we consider in a statute? How do we interpret it? We only look at the common law. So before making the law, what was the issue the common law wasn't addressing? So we have a statute in front of us, we just look at the common law and figure out what issue the statute is addressing, and that's how we'll move forward. And this sort of kind of puts all the power of interpretation into the hands of the judges who are creating the common law. Then Parliament takes the power back, and we have the principle of strict construction. So parliamentary intention trumps everything. We go back to the words, we only care about the words, what the words say. Parliament is wise, they thought about the words a lot, and whatever they actually say is what the law is. Then Judges take the power back again in the 19th century, so we have literal or plain meaning rule. So unless unclear, the words used regardless of the evidence of Parliament's intention and regardless of the consequences. We only care about the words, but the common law is important and the intent is irrelevant. So they're kind of building on the strict construction. The words are important in strict construction, but now they're saying the words are important, but we also need to look at the common law, but we're not going to look at the intent. And lastly, the golden rule: the statute is read in its grammatical and normative sense unless it's absurd. So you can modify the meaning of the words to avoid absurdity and inconsistency. So Gontier, for example, in Jobinal thought that it was absurd that they could consent to fist fighting, and so he modified the meaning of the words without consent. So this assumes Parliament is rational. Judges need to modify language to mean intention, and it also assumes parliamentary supremacy. So if the words are clear, then they have meaning. You can't read into them other things that aren't absurd. R versus Paré. So this is the debate over while committing with regards to taking a murder from second-degree murder to first-degree murder, and that is the case, second degree to first degree, if you are committing murder while committing an indecent assault. So according to strict interpretation, while committing equals simultaneously. They have to be happening at the same time, because there's a principle in criminal law that the statute needs to be read to the advantage of the accused, and the judge in this case thinks it should be read literally. However, if we take a contextual approach, we need to consider the purpose of creating this difference between first and degree murder, and it was to punish people who murder while dominating another person. If we look at the case law, we see that many judges think that while committing only requires a close temporal or causative link between the two. They don't need to be simultaneously. And some suggest that if it's for the purpose of facilitating flight,